Okay, great. Welcome to Navigate Ed, a COPA podcast. I'm Denise Marshall. I'm a parent, grandma, COPA CEO, and your host for today. At Navigate Ed, we dive deep into the most pressing issues for students with disabilities and their families. In this episode, we are exploring a critical topic pushed out and unserved, understanding parent and child rights. When your child is really struggling at school or school is calling you to come get them, or maybe they've been suspended, it's a very overwhelming and frightening time. It can be hard to really understand what your rights are or what you should do. So today we're going to break down your rights under the law, address some common misperceptions, and also speak with two of our legal experts, attorneys Selene Almazan and Amy Bonn. Whether you're a parent seeking clarity with a specific situation, or you're just interested in the rights of students with disabilities and their families, this episode will equip you with valuable insight and empowering information. So let's get started to illuminate, can't say that word, the path towards understanding advocacy, and let's navigate ed together. So Selene and Amy, thank you so much for being here today. Can you tell us a little bit about yourself, what brings you to this work, and what you do for COPA? I guess we'll start with you, Selene.
Okay, thanks for having me. I am COPA's legal director and have been with as their legal director since 2014. I've been a member of COPA since 1998 and have been doing this work. It'll be 39 years in 2025 that I've been doing this work. And I've been doing it since law school, very committed to this work. I ended up having a son who had an IEP all through elementary school and then had accommodations once he went to college. He had an IEP in middle school and high school. And then I had a son who had a 504 plan, and I also got him accommodations in college, post-secondary.
Hey, great. Well, I think it's fair to say you have extensive experience and personal knowledge on this subject. So thanks again for being here. And how about you, Amy?
Yes, I am a consulting attorney with COPA. I've been with COPA for about 4.5 years now. I also have a practice in Nebraska. I represent families of children with disabilities in special education matters. But I came to this area of the law first as a parent. I had practiced law in a different area many years prior and hadn't practiced in a while. But I have kids on IEPs. I have children who are on the autism spectrum. And I had an experience that I think a lot of other parents do, where the very first IEP meeting I attended as a parent, advocating for my child, and knowing that some things were not right, but I didn't quite have the knowledge at that time to articulate why it wasn't right or how to go about hopefully getting the things that were right and that were appropriate for my child. And so I started learning about the law, found out about COPA. I joined COPA about 7 or 8 years ago. I took Celine's class every year. She offers a special education law class to lawyers who are new to the area of law online, and learned a lot about that, and then was fortunate enough to actually become a member or become a team member of COPA. I'm very passionate about this area of the law.
Great. Well, I think you've followed the path that many of our members have taken to arrive here. And so we're thrilled to have you both. And I know, Selene, you also have a private practice in Maryland, correct?
I do. I continue to represent families in special education matters, some discipline, and Section 504 and the Americans with Disabilities Act.
Great. Okay, well, let's dive right in. Today, again, we're talking about students being pushed out of school. And as we're going to explore today, this looks very different for some students, and yet for others, it's the kind of what some of us think of as the same old story, in the sense that students are sent home, suspended, kept out of school, their parents have to come get them. And it can be very stressful on families, not knowing where to go, what to do. And also, having this experience myself, you feel horrible about what it is they're saying your child is doing at school. So that gets wrapped up in it too. I think it's important for us to try to help people sort out between their emotions and what the realities are of what we can expect under the law. So, Selene, every school district has a student code of conduct that spells out discipline. And a lot of times, this is exactly what they're following when a student with disability does something that ends up in a suspension or having them sent home. Do students with disabilities have to follow the student code of conduct, or do they have their own rules?
There is nothing in the Individuals with Disabilities Education Act, the IDEA, that precludes school districts from disciplining a child with a disability for violating a code of conduct, just like any other student. What matters is that if a student is going to be disciplined for violating the school's code of conduct, a school district may not disciplinary action that results in a change of placement. So if a child is disciplined according to a violation of the code of conduct and the school system responds with a recommendation for expulsion, and you have a child who has an IEP, that triggers their due process rights, because obviously that's a change of placement. It also, school districts are also precluded from just disciplining a child without engaging in a manifestation determination review meeting to determine whether or not that conduct that may be a violation of the code of student conduct, to determine whether or not that conduct the student engaged in is a manifestation of the child's disability. And I know that we're going to talk about manifestation determination review meetings, MDRs, but you may not discipline a child in a way that causes a change of placement, an expulsion, whether that is a recommendation for 10 plus days of suspension or any other kind of extended suspension.
Okay, well, can you explain a little bit more what manifestation means? What does that mean? What are they looking for?
So the manifestation analysis is, I looked it up to determine what court considered to be manifestations. And really the issue is that any kind of analysis or determination of the conduct, and whether it is a manifestation, has to be individualized to that particular student. And so an MDR meeting cannot just be, one of the cases that I read, it cannot just be the principal reading out a list of the child's behaviors, or a teacher reading out a list of a child's behavior, then determining that there was no manifestation. You cannot gloss over evidence. You have to look at all of the circumstances of the conduct to determine whether or not the conduct was caused by or had a direct and substantial relationship to a child's disability. So it is an individualized determination, as are all decisions of children with disabilities in the academic setting. And so you look at not just academics, you could look at the educational evaluations. If a child has a functional assessment and a behavior intervention plan, you need to look at the fidelity of the implementation of that behavior intervention plan, look at whether or not the child's IEP is being followed. The short answer is really you have to look at the whole child, the conduct that led to potential discipline, but you have to look at all of the evidence, and parents are an inner part of that. You have to list, teams have to listen to the parent input. You know, one of the cases that I read in preparing for this was a student who forgot to take his medication for his ADHD, and he engaged in a behavior that was very impulsive and was directly related to the fact that he did not take his ADHD medication that day. Obviously, that's the kind of information that only the parent can provide, because the student was supposed to take the medication before he left the house. It's important that parents give input and parents come with information to share with the team so that the team has a full picture of a child and the conduct and the disability.
Very much. Amy, Selene mentioned if there's a change in placement, and I know that the law is pretty specific about what constitutes a change in placement. And I've actually heard schools say, well, we have 10 free days before we have to do anything about suspending a student with a disability. So what does that mean? And can you explain what's that all about?
Yeah, Selene mentioned the rule and the fundamental principle behind the manifestation determination review is to say that schools cannot remove a child for more than 10 days, whether it's in a row or whether it's in a pattern of short-term suspensions. And the idea behind that is that the district would be changing the child's placement if they do that. So you must hold that manifestation meeting, that MDR meeting. And so the U.S. Department of Education has actually spoken specifically to this. There's some great guidance documents that have come from the U.S. Department of Ed. And as we know, guidance documents are not the law itself, but they do provide just what they say, guidance to both state departments of ed, to local education agencies or school districts, and to families as well. There was some more recent guidance that came out in 2022, but there's a great one that came out, and I think we can probably share these out, some of links out to some of these documents with the podcast. But specifically, the U.S. Department of Ed, it came to their attention just what you had noted, Denise, that the idea that schools have 10 free days, that in other words, they don't have to really stop and consider the children's rights or the child's needs, children with disabilities, as long as we're under those 10 days of suspension. And the U.S. Department of Education very clearly came out and said, that's not the right way to look at this. And that's because fundamentally, if we go back to brass tacks and what is it that the Individuals with Disabilities Education Act, that's the federal special education law, what is it that it guarantees to children with disabilities? It guarantees to them a free, appropriate public education. And so if a child with a disability is being suspended, even just once, but certainly over and over again, and especially if it's that pattern of behavior, if it's related to impulsivity, if it's blurting out in class, inappropriate statements, getting into fights, whatever it might be, then it goes back to the core of the purpose of the manifestation right, the manifestation determination right to begin with, which is that Congress and the courts and the U.S. Department of Ed recognize that children with disabilities should not be punished for having disabilities. And so it's that extra layer of protection that says, okay, we're going to look and determine if the reason that this behavior was occurring, that the kid's getting into trouble for, if it's because of their disability. And so if the school is suspending this child over and over again, but even once or twice, perhaps that's a sign that the IEP, the Individualized Education Program, that if you have a child in special ed, you're familiar with, but you may not, if you're just kind of learning about this area of the law, that's the documentation that lays out what the child needs to receive a free, appropriate public education, or a FAPE. And so if the child's being suspended, a child with disability, and that disability manifests itself with some behavioral challenges, well, then those suspensions, those removals, even in-school suspensions, restraint, seclusion, all that stuff, it's a sign that the child is not perhaps getting the FAPE, getting the right specially designed instruction and behavioral supports that they need. So the U.S. Department of Ed was very clear, yeah, school districts do have some flexibility there. They're not changing the child's placement if they're removing the child 10 days or fewer within a school year. However, this is not something to be blasé about. A suspension is it's a very profound experience for a child. It's a very serious occasion in the life of a child. And research shows that, being suspended from school does not help the child gain behavioral skills, does not teach them how, whatever the disability related deficits are that have led to the behavioral challenges, that's not going to improve by removing the child from school. And those are not free days. Those should rather be considered a sign that perhaps this child needs something different, something additional, some sort of change to their educational program. And so that can be a wake-up call for families too, as we're advocating, to say, okay, how do we get ahead of this? We do not have to wait till the child's been the school's proposing to expel the child, or they've been suspended for more than 10 days in a school year. What can we do? This is a red flag for us if there's suspensions happening.
Okay, great. Thank you. And I think, you mentioned the guidance, and I know in my grandson's case recently, there was some discrepancy about whether there had been 10 days or more, because they at first were counting the days that he was suspended from the bus, and then they just said, no, we're not counting those. But when we looked at that 2022 guidance that you talked about from the U.S. Department of Ed, it clearly says if the child has transportation in their IEP, then it is necessary for that provision of FAPE, or the free and appropriate public education you were talking about, and therefore those suspensions count towards the 10-day count. So, I mean, that's a real nuance that, and I don't think the school was trying to do something incorrectly. It's just that they didn't understand it either. And so we were able to point them to that guidance and get the correct information on there. And we also, had to go through and keep track of each of the dates and what happened on that date so we could point back to, and I'm sure you're going to get more into this a little bit later on, but what was the evidence, for example, that his IEP wasn't being followed, or that there was that pattern you were discussing. So I think that's all very helpful information. So Selene, I've heard from many families and that schools get pretty creative when it comes to trying not to get time counted for the 10 days. So under the law, what counts as a suspension, or what counts as part of those 10 days? I already just said one thing, which is the transportation suspension if it's written into the child's IEP, but what are some other examples?
I'm going to give a plug for that guidance from the Office of Special Education and Rehabilitative Services from July 19, 2022, because these guidance documents that are released from the Department of Education are really easy to read. They're like a Q&A. So the question, what counts as a suspension, I believe is in that document. And it can get confusing. And I don't think that schools necessarily are trying to get around what counts as a suspension day. But when a parent might think about a suspension day, that they might think that's the day that the child is sent home and they can't return, 2 days later. So if they get suspended on the 15th, they can't return until the 7th, right? So that's 2 days. However, it's clear and has been clear for, going all the way back to 2009, the department issued a guidance on transportation and children with disabilities. A bus suspension does count as a day of suspension for purposes of disciplinary protections if the child has transportation as related on their IEP. The district does not provide an alternative transportation to school. So an alternative transportation to school isn't mom or dad driving a student to school. It would be something that the district takes on as their responsibility as an alternative to the student riding the bus, because the student has been suspended from riding the bus. So the time that they're suspended from the bus counts as a day, even to school. So that's where it can get confusing. Any other kind of action where a school might put a child on a half a day, that would count as a suspension because they are shortening their days, getting access to things that are already on the child's IEP. Certainly, if a child is sent without any paperwork, you could count that as a day of suspension. So those count, days, suspension from a bus, any kind of send homes, or what they call informal removals. Any kind of in-school suspension is also considered a suspension from a school day, unless three things happen. If a child is afforded the opportunity to continue to appropriately participate in the general education curriculum, and the child continues to receive the services that are on the IEP, and the child continues to participate with non-disabled children to the extent that they would in their current placement. Have to have all three of these factors in order for it to be a non-suspension. So if you go to an in-school suspension, but you're not getting access to the curriculum, you're not getting the services on your IEP to participate with non-disabled students, that's a suspension. school suspension is considered a suspension and counts towards the 10 days.
Okay, so let's say they send the student to the office and they send their work with them, and they let them go down to lunch, but they don't receive their speech and language services and they aren't able to ride the bus. Would that be considered a suspension?
That would be considered a suspension. It's clear that you have to afford the student all three of those factors: participate in the general curriculum, continue to receive the services that are in the IEP, and continue to participate with non-disabled children to the extent that they would have if they were still, participating in the general education classroom and going to specials, like art, lunch, and recess. So that would all be considered a suspension. Spending time in the principal's office or the guidance counselor's office or any other kind of situation where they're removed, their peers, and removed, they're not getting all of their IEP services.
Okay, great. So Amy, if your child starts to maybe have difficulty, some behaviors that are consistent, you're starting to get some notices home about behaviors that are occurring at school, and then the next day you get a suspension notice, you get told to come pick up your child and that they're suspended for 2 days, as Selene said. What should a parent do? What should be their first step?
So I think the big answer to that is to reach out to the child's IEP case manager, to the principal, someone there in administration, and ask to convene an IEP meeting. I think that might be a first major response, but when I'm talking to clients and to families, I will suggest even earlier than that, kind of working on it. Before disciplinary events occur, like even just the teacher emailing you or the teacher telling you at pickup, there's an incident with this, we had to, he had to be sent to the office, or whatever the case might be. Start doing some research and getting some documentation lined up. Denise, you were talking a little bit about trying to get the paperwork together to see what date did this occur, what was this, and that's so fundamental for advocacy for children, is to really kind of get ducks in a row to figure out what's happening and when. But once your child is diagnosed with a disability, do some research, talk to your child's provider to figure out what are the manifestations of this disability. In other words, how does it manifest itself? How does it show itself? What are some of the, is this disability sometimes linked to behavioral challenges? Start understanding it ahead of time, because if you're seeing your child at home or in the community experiencing some challenges, bake that into your IEP advocacy even before challenges start arising at the school, so you can let the team know this is something we've seen at home. It's connected to the child's disability. It's caused by or substantially related to. That's that legal standard. To really to let the team know we want to be preemptive, we want to be proactive, but also you're planting the seed that if we're starting to see these behaviors at school, yes, this is in fact tied to their disability. And as we know, as Congress put into the IDEA and as courts determined before that, we don't want to punish kids for being disabled, right? So we want to really establish early on, this is how it's manifesting itself. And, doing that research, figuring that out, and then keeping track of and documenting what's going on. I always, I tell families, save those emails into a folder, on your computer when you get the email from the teacher talking about specific challenges. And I know a lot of times it's a phone call or at pickup when the teacher says we're having these problems. So I'll tell families a lot of times, grab a notebook, whatever's easiest for you, whether it's a Word doc on your computer or a notebook at home, where you start making just simple notes about, it was February 12th and the teacher came out and told me that this had happened. Just enough to have your own notes about what's going on. And so if you're starting to hear, keep your ear to the ground, find out that these things are starting to kind of percolate, you can call an IEP meeting at that point too, to say, okay, how do we get out ahead of these? Because a good, and when we talk when we're talking about special education rights, we talk a lot about functional behavioral assessments and behavioral intervention plans. Let's get out ahead of it. What is it that's directly preceding the behavioral challenges? How do we get ahead of it to prevent it? How do we get that direct instruction of behavioral skills into the child's IEP as soon as any incidents, we start to hear about them? But then, Denise, like directly to your question about if the child is being suspended, even if it's just a one-day suspension, I would say convening an IEP meeting, getting, asking the school, asking the teachers, asking the related service providers who attend that meeting, what is it that we're seeing? Do we have a sense of, is this happening right after lunch? You know what I mean? If we're starting to have some challenges, is it because there's if math is really hard for the child and maybe that's tied to their disability related deficits? Okay, let's figure out, do we need to, to teach some positive behaviors instead of them acting out when they get frustrated or embarrassed if they're struggling with that? Let's figure out what's going on. And if the school says, we're not sure, we don't really see a pattern to this behavior, ask them to perform a functional behavioral assessment, like I was saying a second ago, or FBA, to take some data, have, maybe the school psychologist come in to observe, to get a sense of what's happening. Because a lot of times when you have a good FBA and then a good behavioral intervention plan, those can work beautifully to, to identify what's the trigger, to identify what's going on, and then proactively meet the child's needs, provide them the instruction that they need. So ask for those things. And then, if for whatever reason you hear, oh, we don't know, it's really not a big problem, this was an isolated event, it's kind of a one-off, don't forget that you have the right, all the IEP advocacy tools in your toolbox. You can ask for prior written notice that says parent asked for a, functional behavioral assessment and behavioral intervention plan, and the team decided they don't need one, right? And then you can kind of go back later to say, hey, remember, we really need to have this in place. So I think convening the team, and one thing I want to toss out there, think broadly. We can look we can look online and find reliable sources of information about what are the symptoms of of a specific disability that a child has. How does it manifest itself? But even things like specific learning disabilities, the research out there really talks about the difficulties that individuals, as children and then across the lifespan can experience. So people with specific learning disabilities who perhaps are never become fully functionally able to read, they engage in a lot of avoidance. And we can imagine why that's the case. Kids in school are, like I said, frustrated or embarrassed, and they start acting out as a result of that, because hey, I can get removed from class, I can go to the office, or I might get sent home, and that's preferable to being in class. Even if the child's not really thinking it through that way, a lot of times it kind of manifests itself that way. So think about that. Be as proactive as you can. And, teachers are busy, school administration people are busy, but really getting them on board to look early and then get out in front of it is, I think, an important advocacy tip.
Yeah, I really like what you said about getting information about the types of behaviors that the child exhibits or how that is related to the disability into the IEP. Again, I saw that with my grandson's, he has Down syndrome and he also has ADHD. And I was surprised in the MDR that they were actually trying to make a little noise about maybe it not being, because not all children with Down syndrome do that, or not all children with ADHD do that particular behavior. And we were able, luckily, those things were documented both in the IEP and in the evaluations. So we and in the data. So we were able to kind of point to all these things and say, well, wait a minute, and they really had to say yes. Well, it felt like they had to say, yes, it is a manifestation. Though there was a moment in time there where I think they were trying to cast doubt on that, I guess. So yeah, I love that strategy, and it's not something I know that I would have thought of before. So that's a good one. So Selene, is it possible that a student may be protected under the IDEA or 504 if they don't already have an IEP or a 504 plan?
Yes, in order to trigger those protections that a student would have under the IDEA or 504. So if the school district is deemed to have knowledge that the child is a child with a disability, say a child is in the middle of being evaluated for an IEP, or a parent comes in and says, my child has ADHD or my child has anxiety and I need a 504 plan, I need a 504 meeting, you could say that the school district is deemed to have knowledge, and then the child is entitled to those protections, even if they haven't been found eligible at the time that the discipline is proposed or imposed to the student. I do think what Amy was saying about families collecting their own information, I think that one of the things that you and I have talked about, Denise, is asking questions about what happened before the behavior. What did you notice? What was the child being asked to do something that was really hard academically or behaviorally, and then the child engaged in that behavior? Was that an antecedent to the behavior? Those are all questions that parents should ask when told that a child is struggling. I know for a fact that children don't go to school every day and decide to engage in behavior that is challenging for the adults around them. That's not the way that it works. Children want to do the right thing. But some children, because of their disability, can quickly dysregulate and have a difficulty pulling back and then engage in behavior that then leads to discipline. So one of the things that I always ask clients is what was happening before. Was it at recess? And this is inherently unstructured. And does a student dysregulate and engage in behavior during unstructured times, or when a student has to walk down the hallway to lunch and a student engages in behavior? So, look at those kinds of what was going on before that behavior, and also what happened after the discipline was imposed, like being sent to the office or being told to sit at your desk or missing recess, which is never really a very good consequence for children. But look at all of those things, those are the data points. And also I have found, unfortunately, that does start engaging in some behaviors, and teachers, staff, administration is keyed into some behaviors. Sometimes schools key into behaviors. You had a child without a disability was engaging in those behaviors that they might look away or not respond to. And so try to figure out if those behaviors are really what we call low-level behaviors and should be ignored and not responded to, because maybe this child might be looking for attention or to escape an activity. And that's why Amy was talking about a functional behavior assessment. That data from a functional behavior assessment should be able to suss out why the child is engaging in those behaviors. Many years ago, when I was a young woman, I had a student who kept on getting sent to the principal's office over and over and over. And we came to the IEP meeting, and come to find out the principal was taking him to McDonald's. I mean, this was a million years ago, right? When you could take a child off campus. And I remember having that aha moment in an IEP meeting. Well, of course, I would engage in those behaviors if I knew the principal was going to take me to McDonald's or bring me McDonald's. I mean, that sounds like a pretty cool deal when you're a child in elementary school. So, really look at what happens after the discipline might be imposed on the child, as well as what happened before. What happened? Did you ask the child to read out loud? And they're not a fluent reader. And so they acted out in order to get sent out of the class so they don't have to read out loud. All those things I think are important to look at.
Yeah, that's good points. And I think both asking the questions as well as asking for an IEP meeting right away before you wait until the behavior escalates. I know in my grandson's case, in a lot of districts, it's like a graduated. So the first day is 1 day suspension, then it's 2, then it's 4, then it's 5, whatever. And that was a mistake I think we made, that we didn't ask for the meeting sooner to go over all of that information. Unfortunately, the district wasn't taking data as they should have, but we were still able to find out a lot about what was happening or what was not happening through the incident reports that they filled out that went along with the suspension notices. And that became the data for the fact that they were not following the IEP and not providing, and doing some other things, as you said, not ignoring those low-lying behaviors, like instead of doing his work, he would go lay on a blanket. It happened to be another student's blanket, and the teacher said, you need to get up and do your work. And when he failed to do that, the teacher yanked the blanket out from under him, which, on one hand, I say to myself, I can't believe they would do that. And on the other hand, I think sometimes when in the heat of the moment, and when teachers are thinking about, just providing some kind of consequence or response to something they think is inappropriate, it gets into that control mode. And rather than thinking, okay, this is a low level behavior, I can move on to something else and come back, that they feel like I have to get a handle on this right now. And it ends up escalating everything. So, and getting that kind of information early, I think, was helpful before it really came to the manifestation determination meeting, because people seemed freer to say those things than they did when they knew that we were looking at it with the lens of, are you following what is IEP supposed to be? So anyways, I think those are really important points. So Amy, how does a manifestation determination meeting work? Who's there and who runs it?
So I think that the number one thing to keep in mind for families during this very stressful time, because if the school has let you know that there's going to be an MDR, manifestation determination review meeting, that means your child, the school is either proposing to expel your child, or you're looking at the 11th day of suspension, whether it's in a row or a series of shorter suspensions. So the first thing to remember is that while the suspensions or the proposed expulsion are not good things, the MDR is a good thing. This is an important right for children with disabilities and for their families. And this goes back to, historically, with the whole point behind the IDEA, is it's to prevent schools from being able to unilaterally exclude children with disabilities from school. So this is the chance for the parent to come in and to, explain how the disability has been affecting their child, how that shows up in the child's behaviors. So essentially, as we've been talking about so far, it's if it's just suspensions, it's that 11th proposed day of suspension, or if they're, maybe you've had a few 2 or 3 day suspensions, and this current one is going to take you over to 11 or 12 days. The school needs to convene an MDR meeting, and they need to do that within 10 days of that proposed discipline that's either the expulsion or over the 10 days in one school year. According to the regulations for MDRs, it's the MDR team is composed of, quote, relevant members of the IEP team. So it's,
not necessarily all of them, but who might be determined to be relevant.
Yes. And so you can expect someone from administration there, obviously the parent. Keep in mind, though, that you can ask and say, this is a relevant person. And even though the law does not require this, it's never a bad idea to put it in writing. So shoot an email and say, I believe it's important for, maybe if it's a school counselor who has a relationship with the student, or if there's, a couple of general education teachers who have seen a lot of what's going on. I think I would always recommend to have the school psychologist there, or maybe not always, but often it can be useful to get some sense of, okay, let's understand how disabilities are verified at by school districts, so we can kind of get a hold around what is the disability, what is the condition that the child has. All right, how is the behavior that the child's being disciplined for and is now being proposed again to be disciplined for? How is that caused by or substantially related to the disability? So you will come away with, and maybe we should kind of look at what the result is, because if the team says yes, if the outcome of the MDR meeting is yes, this conduct is a manifestation of the child's disability, that's what you're going for, that's what you're hoping for, that the conduct was caused or related to, substantially related to the disability, that means that the school district cannot suspend that child, cannot remove that child, can't expel the child or can't suspend that child for the 11th or 12th day, because it's a manifestation of their disability. Unless, and there are 3 exceptions. Sorry, go ahead, Denise.
I was just going to clarify. So you're saying, so let's say they have a 3-day suspension and the manifestation determination meeting is held on the first day of that, then that child goes back to, and it is found to be a manifestation of the disability, the child goes back to school the next day to the
Correct.
classroom that they came out of.
Correct, exactly. And the threshold is once you're having the meeting, that means it's either, it's that we've already had, up through 10 days and maybe, or, maybe you've had 8 days in the past and now you've got a 3-day suspension. Right. And so we convene the MDR. And if they say, yes, it's a manifestation, then the child goes back to their placement, their educational placement, and they cannot be removed, for those additional days. So that's what you're looking for is, yes, this is a manifestation of the child's disability. There are 3 exceptions in the law. So if your child has brought a weapon to school or to school grounds or to a school function, if your child has brought drugs or, attempted to sell a controlled substance at school, on school grounds, or at a school function. And the third one is if your child has caused substantial bodily injury to someone at school or on school grounds or at a school activity, then even if the team says, all right, yes, this was the misconduct here was substantially related to or caused by the child's disability, the team can still remove the child to an interim alternative educational setting for no more than 45 days. And so those are those 3 exceptions for serious, conduct that can still happen. And so you want to, as a family members, we need to know that. For lawyers and advocates, we need to be aware of that so you can let your client know what may still happen, even if we do determine that it was a manifestation. The other way that you can, quote unquote, win the manifestation determination is if the team determines that the child's conduct resulted from the district's failure to implement the child's IEP. So that's another thing to look for. Even if you're thinking, I don't, maybe we can't make the connection between the misconduct and the disability, but it says here that they're supposed to be receiving, certain accommodations, certain level of supervision, and that has not been happening. So,
Okay.
either one of
So
those.
those are the two questions they're charged with
Exactly.
answering. And as long as the answer is either yes, it's a manifestation, or no, they haven't been providing the services or following the IEP, then the child is eligible for the protections.
Yes, right. Then the child comes back to placement. They can't keep removing the child past those 10 days in the school year. If the child's misconduct was connected to the failure to implement the IEP, yes. And so those are the key things to keep in mind. That's why having that documentation is so crucial. There's before I did my very first MDR meeting as a lawyer for a family, I had looked up, there's Rights Law is a site that a lot of families who are familiar with COPAA are probably also familiar with Rights Law. There's a great, I guess kind of an article written there by Bill Brownlee, who's an attorney. And it's a great snapshot of what this looks like. There's a DSM-5, which is that how conditions, disabilities that involving mental health are diagnosed. And it really does a great job of, obviously, it's the diagnostic manual of laying out, here's how disabilities are manifested. Here's how they show up. So if you don't have that, that's fine. You can go and look up online from credible sources saying, this is, when a child is exhibiting these symptoms or these behaviors, that's how they're diagnosed with this condition. So if we know if they're exhibiting those behaviors at school or these challenges at school, that means that that's connected to the condition or to the disability. And so one thing to keep in mind is during the MDR meeting, you don't want to let the school members of the team just kind of start in and they're reading and they're saying, here's what happened and here's what we're seeing. And then, because I actually have been to a meeting where it opened up with a school administrator saying, well, I'm looking at what happened, and to me, it does look like a manifestation. And this was like, nope, we're here to discuss, right? This is not a foregone conclusion. And so, just kind of chime in. It doesn't have to be structured in a particular way. Start talking about what evidence you have, what information you have. Comb through the child's evaluations that the school district has done, because like you were saying earlier, Denise, if there is in their own language, this is how the disability is showing up in the classroom, well, there you go. And then you can really make that connection. Or if the child's been moved to a more restrictive placement by the school because of certain behaviors, well, there you go. And you can see that it's connected to the child's disability. So really try to, really work on injecting that, in order to show the team, yeah, there's truly a connection here.
Okay, great. Well, So the manifestation determination meeting is over. They've, determined that it is a manifestation. The child goes back to school, and 3 days later they get sent home and suspended again. Is that legal, Selene?
Well, technically, yes, you have to do the whole analysis again for the behavior. As Amy said, a new MDR meeting that's going to look at everything about a student. The nuance to this is obviously is that if you are already at 9 days, or you're already at days, because it's 10 school days throughout the year. And even if it is found to be a manifestation, they don't get to start over from 1 to 10, right? Because it's cumulative. And because they them, they have been subject to a suspension, even though later on it was found to be a manifestation. They don't get you don't start the call over, I don't believe. So yes, can continue to be suspended. Yes, you have to do another manifestation determination. If you're getting into, more than 10 days, then obviously you have to look at the IEP. I would encourage people to look again at the functional behavior assessment, look at whether or not the behavior intervention plan is being implemented with fidelity, do a whole other analysis of the behaviors. Maybe it's a new behavior, maybe instead of running out of a classroom without permission, now they are throwing objects in the classroom, like chairs and things like that. So that might be a new behavior analysis, whether or not it is a manifestation. Look at the information that the team has, that the parent has. And really, if it's 10 days or more at this point, and you're not through the school year, really, that's a time to look at the services, the IEP placement, the functional behavior assessment, the behavior intervention plan, and figure out what's going on with the student. And that obligation is on the school. That they are the ones who are supposed to be providing a free, appropriate public education in the least restrictive environment. That obligation.
Right. And if the student keeps getting sent home, then something's not right with all of that.
Right. There's something
Yeah.
going on. Right. Because again,
right.
you don't go to school in order to engage in behavior that leads to discipline.
Right. I mean, I have to say that was one of my biggest surprises diving into all of this, was that they could suspend them again. I always thought that when you're reading it just kind of like about, something else, you think, oh, well, it's found a manifestation of the child's disability, so that's it, that's settled. And now it makes more sense to me that it might not be settled, because it might be a new behavior, or it might be that they still aren't following things, or maybe they are following it, but it's not working. And so those are some positive reasons, I think, to have another MDR that I hadn't considered when I first heard about it. I was just like, what do you mean they can still suspend them? So yeah, it's definitely confusing. And speaking of continuing to suspend, Amy, are there some red flags that families should think about? Like maybe they already have an advocate, or maybe they've been doing this on their own, but are there some red flags where they might want to consider whether or not they should hire an attorney?
Yeah, so I think one thing to look for is, in every child's IEP, there's a section on, does the child's behavior impede learning? And, whether that's their own learning or other children's learning. And if they've marked that, if there's, documentation in the IEP, or just that just from what's been going on, it's clear that there's behavioral difficulties. But when you look at the IEP, there's no clear targeting of that. There's nothing addressing that. Or if there is something addressing it, it's not very robust. There doesn't seem to be a lot of there. That can be a time to say, well, if the need is here, then it is, like Selene was saying a second ago, the school district has these responsibilities. And so while it can be helpful to advocate as parents, and we want to start learning our rights and our children's rights, it's a responsibility of the district to say, okay, how are we going to provide specially designed instruction to help this child develop skills that they are currently struggling with or lacking due to the disability? Because like Celine's saying, it's not a choice that children come in, I'm going to misbehave today and get suspended. It's because of their disability, they are lacking skills to help them meet the expectations that are placed upon them by the school and by that code of conduct. So the district needs to work with them on that. So a lot of times I think if nothing is speaking to that in the IEP, that is a sign that they're not counting the days the child has been suspended, even things like in-school suspensions, they're not documenting them. That can be a red flag. I have seen, unfortunately, before where there was a case manager who misunderstood the 10-day rule and thought it was 10 suspensions. So this child had been removed for something like 43 days in a school year. And so you want to look and just familiarize yourself. Okay, what are my rights with this? COPAA is obviously a great resource, to say, okay, how many days, tell your friends if you're in parent groups on Facebook or whatever it is with other parents of children with disabilities, just have in the back of your mind, even if your child has not been suspended yet, what's the trigger? When do I start needing to look and say, something does not seem right here? And especially if it's school removal, disciplinary exclusion, that is a big deal. And it tends to make things worse. Right? We don't remove a child that can't read because they have a specific learning disability. We don't say, oh, I know, we'll have less school for them. That will solve it. Right. And so that's certainly not the case with behavioral challenges. And so if something is askew, it can be time to say, okay, perhaps we do need to talk to an attorney because we're going way over the 10 days. We're not following it, or we're repeating these. If you have an MDR and you lose it, you can appeal and, to try to fight that. And one other note I was going to say, when there is a finding of a manifestation, that means that the district either needs to do an FBA, a functional behavioral assessment, and put a BIP in the child's IEP, or revise it if they have one. And then even if it's not a manifestation, the district needs to, if appropriate, they need to do an FBA and a BIP. So always lobby for that. Even if you get the no, you don't get the win the MDR, that is a chance to say, okay, we're still going to make this situation better. We're going to ask the team to do a sound and solid FBA and BIP and really address these so that the child can develop those skills that they need, so that they're staying in school and learning with their peers.
Okay, great. Who do they appeal? Who do families appeal to? To the same person that ran the first one, or is there a different process?
You can appeal it. So you would file for due process. And so it's filing for due process, just like we do for other, for deprivations of FAPE or other violations of the IDEA. And it's actually on an expedited time frame. So yes, so it's quicker than the normal timelines to, with the idea of getting that child back into school more quickly. So you can certainly challenge it. So the decision, an MDR team decision.
Okay, great.
Yeah, I mean, I think that one of the things that I have a pet peeve about is that you have, as Amy said, teach skills. That behavior intervention plan or IEP goals should be about teaching the student the skills that they need so that they do not engage in that behavior. It's not about corralling a kid and managing a kid and not teaching them how to different ways of communicating besides that behavior. And I think that's a nuance, I think, that I believe parents intrinsically understand, because when you're raising children, you are not hopefully an authoritarian, but you want to teach them how to not have a meltdown in a grocery store. What are those skills? What are those proactive skills? When my kids were little, I would say, okay, we're going to go to the grocery store. It was like a little social story I would do. Store, you're going to write in the cart, this is what we're going to buy, help me pick it out. And, basically no tantruming over candy and, donuts or whatever, right? I mean, but and you're teaching your child how to engage in behavior that it's not going to get them in trouble with you, right? And so for students in school, it is an obligation for schools to teach those skills that children need so that they don't engage in that behavior. It's not about containment, it's not about managing, and it's not about corralling. It's really about those skills that you need.
Well, I think that's an excellent point. You both have said that, it's the school's obligation to teach them. The way they do that is through their IEP and through their program and services. And if there's something that's happening that's interfering with their education, then they should do that FBA and the behavior intervention plan. Too often, I think families are made to feel as if they should be doing something to control their child or to stop them from behaving that way at school. But the obligation in this situation really is on the team and parents, of course, and on the school, but parents are part of the team to help, figure out what's going on, what's missing, what their child needs. But it's the school's obligation to really implement the program. So
Right.
thank you both for such an informative session. Is there anything in closing that you want to share with families to remember? We've had an awful lot of information here today on a really complex topic, I think. So any last words?
Just that schools can't tell families to put a kid on medication in order to control behavior. That's not allowed. If a school is telling a parent, why don't you take them to the pediatrician, or why don't you take them to a psychologist or psychiatrist? That's up to the school, because that's really a child find issue to evaluate in all areas of suspected disability. And so that's really where having a lawyer who understands the law might help a parent figure that out, because lots of times families do that. They do take a child to be evaluated and they pay for that, or they take a child to a pediatrician to get some medication so the child can go to school. And schools are not allowed to do that, and a lawyer can tell you. So that's my 2 cents.
Okay, great. Thank you, Selene. Amy?
I guess my 2 cents is just a reminder that, this is such a tough time. As parents, we feel that our child is being vilified, we are being vilified. It's a tough spot to be in. To remember that your child and you, under the law, have rights in this context. Your child has a right to an education. They have a right to be educated with their peers. They have a right to that appropriate instruction that helps them develop those behavioral skills that we've been talking about. And that's something that's an integral part of the law. And so it's, how do we improve this? So it can be easy to get caught up in the doom and gloom of this, but it's okay, how do we effectuate these rights? How do we take one step forward and improve this one day at a time, so that we can get the child where we want them? And it really can work. Good advocacy and understanding your rights and how the process works can really work.
Yeah.
Great, thank you. And I know that's something Selene always reminds me. It's a process, take each step, and it does eventually come together, hopefully. And if not, then there's another step. And those are things that we'll get into in future episodes. But thank you both again for your time today. As we wrap up today's episode of Navigate Ed, remember that advocacy starts with each one of us. Please visit www.COPAA.org. Join, get involved, stay informed, and let's navigate ed together. Thank you all and have a great day.
Thanks.
All right. Thank you both.